third point is just a few points about the language. So sovereignty seems to be a big thing. International legal thinking begins with sovereignty. When there wasn't sovereignty, there wasn't international legal thinking, nor international legal rules. Now, sovereignty is important, but it's also really, really indeterminate and unhelpful, because it's always two sovereigns that meet each other, that interpret their sovereign rights from their own perspective, and they clash. So in terms of use of force, the one who first uses force will always say that I have a sovereign right to determine when it is a situation that calls for self-defense. And the one being attacked is, how can you say that? So my sovereign determination is that my territorial integrity and political independence have been violated. And that's the end of that. There's nothing more to be said. You can't derive from sovereignty some miraculous thing that resolves your problems. Sovereignty is the problem, it's not the solution. Then there's the question of state responsibility and attribution. That also seems to be all over the place. It used to be there when I was participating in the early stages of the creation of international environmental law. And we were worried that most of the polluting activity that across boundaries comes from private activities, private industries, private industry. How can we regulate? The states will say, I have nothing to do with it. Why should I pay? Why should I be accountable? Because it's these industries. How do you attribute? And then we came to this miraculous word, due diligence. Okay, so a state should be diligent. A state should exercise supervision within it so that it sees what goes on there. Now, what kind of supervision? The third world countries were immediately saying, well, you know, half of our territory is completely unpopulated. We don't have the resources to send people to see what happens in that remote village, for instance, if they pollute a little bit of your land. We have bigger problems, frankly. And, you know, that's not an unreasonable position. It's a standards position in which you can deal with it once there is solidarity between you and them. And you say, okay, so we don't apply it to you because we understand your situation. But if there's not solidarity, then you just want to hit them. Due diligence. And then there's this thing, customary law. So I cannot imagine a statement about the length, the duration of customary law that I wouldn't have seen in the course of these years. It's one of these amorphous things that has always been. So lawyers revel in thinking about what is customary law. It has these two elements, practice, opinio juris. There must be something must have taken place in the past, and people must think that what happened in the past must be because a legal obligation committed us to acting in such way. Custom or past practices are elevated into the level of being a customary law if the people who participate in that practice think that they are bound to participate in that practice. The well-known problem there is that why would your conviction that something is already binding make that something binding? So your mistake of thinking that when you followed this, you followed the legal rule, that then creates the legal rule. Well, it's just, no, law is a vocabulary. It's a technical vocabulary in which you can do things. You have interests, you have ideas, values, a project. And then you turn to your lawyer and you say, well, dear lawyer, how can I get there? And the lawyer produces that set of words to you using expressions such as I put there. This is my last slide.